Ladies and gentlemen, today's hearing is the third in a series of hearings this subcommittee is conducting this year, examining voting and election administration in America. Today, we will examine three types of state and local election administration laws: those requiring voters to present identification to vote, those requiring voters to provide documentary proof of citizenship in order to register to vote, and those governing the provision of multilingual voting support. Since the Supreme Court back in 2013, in the case of Shelby County versus Holder, a number of states have adopted very strict voter ID laws requiring voters to present a qualifying voter ID in order to vote, some doing so immediately after the court's decision. Voter ID laws have been shown to disproportionately burden minority voters. That is a demonstrated fact. I don't believe there are many experts who would dispute that. Voter ID laws have been shown to disproportionately burden minority voters. African American and Latino and Native American voters, for example, are less likely to have qualifying forms of ID. They are particularly burdened by the cost of obtaining IDs. And studies have shown that strict voter ID laws disproportionately decrease minority turnout. We should all be concerned about that. Voter ID laws adopted in Texas and my state of North Carolina imposed particularly troubling burdens on minority voters. Now, before the Shelby decision, both Texas and North Carolina had to obtain pre-clearance of their voter ID laws from the Department of Justice. Within days of that decision back in 2013, these states imposed restrictive voter ID laws, laws that their legislatures knew would not have survived the Department of Justice's review. Federal courts found that the laws were enacted with the intent, not just the effect, but the intent to discriminate against minority voters. The courts relied on evidence that the legislatures knew the laws would disproportionately burden minority voters and provided pretextual justifications for enacting them. In my state of North Carolina, a federal court found that our voter ID law, in particular, targeted African American voters with almost surgical precision. And I put that in quotes, almost surgical precision. That was a federal court. The Texas and North Carolina voter ID laws illustrate the critical role the Voting Rights Act played in protecting the rights of minority voters and exemplify the need for Congress, for us, to enact new legislation to revitalize federal protection of minority voting rights. Like voter ID laws, laws requiring voters to provide documentary proof of citizenship to register to vote have been shown to disproportionately burden minority voters. Studies, qualitative studies, have shown that obtaining the required documentation can sometimes cost in excess of $1,000, leading some to characterize these laws as imposing a modern-day poll tax. These documentary proof of citizenship laws have been shown to disenfranchise tens of thousands of voters and are justified by little more than unsupported claims of voter fraud. Lack of access to multilingual voting support also poses a significant burden on minority voters. Studies, credible studies, have shown that language minority voters are more likely to be registered and turn out at a higher rate when they have access to voting information in their native language. And I hope we will get into that today. Despite this evidence, states and localities continue to deprive voters of multilingual voting support. The testimony provided today will help us, will help this committee as it seeks to understand what needs to be done to ensure that voter ID laws, proof-of-citizenship laws, and laws and processes governing the provision of multilingual voting materials are non-discriminatory. We must do that. We should be making it easier for all citizens to vote, not leaving state and local governments with unchecked authority to enact legislation that imposes discriminatory barriers to the ballot. And so I know this was a little long, but I look forward to hearing from today's witnesses and working with my colleagues on both sides of the aisle on these important issues.